We're going to take a look at sections 91.24 and 35.1 of the Canadian Constitution, which define the constitutional relationship of the Canadian government to their Aboriginal people. This examination will come from excerpts of the Federal Power and Federal Duty, reconciling sections 91.24 and 35.1 of the Canadian Constitution, article by Brian Bird. So some of the laws, rules, and duties that I've extracted from this article for future analysis on a law school exam or a legal paper or NCA exam start with section 91.24 from the 1867 Constitutional Act itself. Parliament has exclusive legislative authority over Indians and land reserved for Indians. And then later on, from the 1982 Constitutional Act, Section 91.35 recognizes and affirms Aboriginal rights and treaty rights. From the case of the Sparrow case, these two provisions are to be read together. Federal power must be reconciled with federal duty. Some of the duties extracted in the Sparrow case from 91.35, the Crown must act honorably in dealings with the Aboriginal people, and the Crown has a fiduciary duty to the same, which will be broken down a little bit more as we continue. From the Mikisew Cree First Nation case, the fundamental objective of the modern law of Aboriginal and treaty rights is the reconciliation of Aboriginal peoples and non-Aboriginal peoples and their respective claims, interests, and ambitions. From the Mitchell v. Peguis Indian Band case, the federal Crown alone bears the responsibility to provide for the welfare and protection of Native peoples in Canada. From the Guerin case, where the federal government manages the surrender of reserve land pursuant to its authority under Section 91.24, it owes a fiduciary duty to act in the best interest of the Aboriginal people in question. Again, from the Sparrow case, federal power must be reconciled with federal duty, and the best way to achieve that reconciliation is to demand the justification of any government regulation that infringes upon or denies Aboriginal rights. From the Vanderpeet case, the Aboriginal rights recognized and affirmed by Section 35.1 must be directed toward the reconciliation of the preexistence of Aboriginal societies with the sovereignty of the Crown. And one of the most important cases, the Haida Nation case, the Crown, federal or provincial, depending on the circumstances, has a duty to consult and potentially to accommodate the interest of Aboriginals when it has knowledge, real or constructive, of the potential existence of an Aboriginal right or title and contemplates conduct that might adversely affect it. We'll take a note from the author Bird, his comment on the results of that Haida Nation case. And he says, the language in Haida Nation is momentous. It places upon the Crown an obligation to determine, recognize, and respect the still unproven rights of Aboriginal peoples through honorable negotiation. In the Guerin case, when, as here, an Indian band surrenders its interest to the Crown, a fiduciary obligation takes hold to regulate the manner in which the Crown exercises its discretion in dealing with the land on the Indians' behalf. And again, from the Sparrow case, the fiduciary duty of the Crown serves as a general guiding principle for Section 35.1, mandating the Crown to act in a fiduciary relationship with respect to Aboriginal peoples that is trust-like rather than adversarial. And author Bird repeats this point that was earlier stated in his article to illustrate the current circumstances as we as a country, and the author Bird pushes towards continued reconciliation. And he says, the unequivocal statement by McLaughlin, CJ, and Haida Nation bears repeating. He says, put simply, Canada's Aboriginal people were here when Europeans came, and were never conquered. Many bands reconciled their claims with the sovereignty of the Crown through negotiated treaties. others, notably in British Columbia, have yet to do so. The potential rights embedded in these claims are protected by Section 35 of the Constitution Act of 1982. The honor of the Crown requires that these rights be determined, recognized, and respected. This in turn requires the Crown acting honorably to participate in processes of negotiation. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.